My ex-boss registered my judicial translations as his own before the Bar Association. $1 million cases with my work, and when I discovered it, he threatened to destroy my career. But he didn't know I recorded every meeting and kept every delivery with witnesses in 3 countries. There are threats that are delivered quietly, not with shouting, not with fists on the table, with the controlled calm of someone who believes they have enough power that they don't need to raise their voice. With the confidence of someone who has done this before, and it has worked before, and who sees no reason why this time should be different. When Attorney Herrera told me, in an almost conversational tone, that if I proceeded with my intentions, he would make sure no law firm in the country would ever hire me again, he said it just like that. Calm, like someone commenting on the weather. What he did not know was that I had arrived at that meeting with my phone, recording from the moment I walked through the door. And that recording, together with everything else I had gathered over the previous months, was exactly what I needed to turn his threat into the most expensive mistake of his career. My name is Lucia. I am 38 years old. I am a certified judicial translator and interpreter specializing in international law, English, French, and Portuguese. It is a specialty that very few people understand well from the outside, but that within the legal system carries enormous weight. A poorly made or incorrectly attributed judicial translation can change the outcome of a case, can affect the validity of a document before a foreign court, can determine whether evidence is admissible or not. I have been in this specialty for 12 years. I built my reputation with the slowness and solidity with which reputations that last are built, case by case, delivery by delivery, with a quality standard that over time became my personal trademark in the field. I worked for Attorney Herrera's firm for 4 years. 4 years in which I was the exclusive translator for his international cases, which were the largest, the most complex, the ones he charged the most for, the ones that built him the reputation as a specialist in cross-border litigation that he has today. That reputation was built in large part on my work, and he knew it perfectly well. Attorney Arturo Herrera is 55 years old and is, in terms of public visibility, one of the most recognized litigating attorneys in the country in the field of international arbitration and cross-border commercial disputes. His firm handles cases involving companies from several countries, contracts in multiple languages, proceedings before international arbitration tribunals. The kind of work that requires not only legal knowledge, but linguistic precision of the highest level in specialized technical languages. That precision was what I contributed. When I joined the firm, I was 28 years old with an emerging reputation that Attorney Herrera used intelligently. He integrated me into his most important cases, introduced me to clients as part of the team, and in the right context, my presence gave him technical credibility that he alone could not generate. What he was doing in parallel, what I discovered 4 years later, was systematically appropriating my translations before the bodies that certified them. The judicial translation certification system works in a specific way. When a translation is presented before a court or an international arbitration body, it must be certified by an authorized translator whose professional registration supports the validity of the document. The certifying translator's name appears on the document and is recorded in the case file. What Attorney Herrera had been doing for 4 years was presenting my translations with his name and the name of a translator associated with his firm who had the certification but had not done the work. I did the translation. I delivered it to the firm. The firm presented it certified under another name. My fees were received as an external contractor, without my name appearing in any official document of the case. The technical credit, the certified authorship, the professional record that builds reputation in the field, all of that remained in someone else's name. And the cases that those documents supported were cases that Attorney Herrera won and that generated contingency fees of several million pesos. Millions built, in part, on translations without my name. I discovered it through a coincidence I could not have planned. A translator colleague working in another country contacted me to ask for references about an international arbitration case in which she had seen cited a piece of technical translation work that she recognized as similar to my style and methodology. The case was public because it had been resolved by an arbitration tribunal whose rulings are published in accessible databases. She sent me the case number. I looked it up. It was a case I remembered. I had translated it 2 years earlier. A technology licensing agreement with technical annexes in 3 languages, a job that had taken me 3 weeks and had involved considerable terminological research in a highly specialized field. In the tribunal's file, the translation was certified under the name of a translator I did not know, but who turned out to be an employee of the Herrera firm who had judicial certification, but who, as I was able to determine afterward, did not remotely have the technical specialization necessary to have done that work. I looked up other cases. The pattern repeated itself. I did not go immediately to Attorney Herrera. I went first to my own archive. 12 years of work had produced a filing system that was exhaustive by professional necessity. In judicial translation, every delivery must be traceable because clients, courts, and certification bodies may require verification at any time. Every project had in my archive the original version of the source document, the delivered translation, the delivery email with date and time, and in many cases the technical consultation exchanges with the client during the process. I reviewed the 4 years of work for the Herrera firm. I found deliveries I could directly link through the emails and file metadata to documents that had later appeared certified under another name in the files of public cases. It was not 1 or 2 cases. It was 23 cases over 4 years. 23 of my translations presented with someone else's certification. And when I added up Attorney Herrera's contingency fees in those 23 cases using the public information available in the arbitration tribunal records, the number I obtained was of a magnitude that cost me effort to process as I looked at it. I also had something else. During the 4 years I worked for the firm, I had developed the habit of recording my briefing meetings with the legal team, where they gave me the technical instructions for each translation. I did it for purely practical reasons. The instructions in complex cases are long and detailed, and it is more efficient to record them than to take notes while trying to follow a technical explanation in real time. I had recordings of 47 meetings. In many of those recordings, Attorney Herrera or his associates gave me specific instructions about translations that later appeared in judicial files certified under another name. His voice, his instructions, my work, someone else's name, all recorded. I went to see him on a Tuesday afternoon. I did not tell him why I wanted the meeting. I simply asked for a slot in his schedule to discuss pending projects, which was the kind of meeting we had dozens of times. I arrived with my phone, recording from the moment I entered the building's door. I presented what I had found without excessive preamble. I showed him 3 specific cases with the complete documentation, my delivery, the delivery email, the file metadata, and the certified version in the tribunal's file under someone else's name. Attorney Herrera listened to me with the expression of someone who is calculating in real time. When I finished presenting the 3 cases, he told me that what I was describing was an incorrect interpretation of how the certification processes worked in his firm, that there were administrative and legal reasons for the procedures they followed, that I had been hired and paid for my work, and that the certification process was an internal function of the firm that was not my concern. I told him I understood his position, that perhaps there was room for a broader conversation about how to resolve this in a way that was satisfactory to both parties. It was at that moment that he told me, in the tone I described at the beginning, that if I proceeded with my intentions, he would make sure no law firm in the country would ever hire me again. I thanked him for his time. I left the building, and I called my attorney from the parking lot with the recording still running. Attorney Fernanda Castillo has spent 16 years in intellectual property and labor law with specific cases in the professional services sector. When I described the situation to her by phone, she told me she needed to see me that same afternoon. We met 3 hours later. I showed her everything: the 23 documented cases, the delivery emails, the metadata, the meeting recordings, and the recording from that afternoon, where Attorney Herrera's voice clearly described what he would do if I proceeded. Attorney Castillo listened to the recording twice. Then she looked at me and told me that what I had was extraordinary from an evidentiary standpoint because it resolved the problem that normally makes these kinds of cases difficult: plausible deniability. That with that recording, Attorney Herrera had no plausible deniability, that he had declared his intentions out loud, and that changed the legal dynamic completely. She explained the available lines of action. A complaint before the Bar Association for professional misconduct related to fraudulent translation certification. A civil lawsuit for authorship appropriation and financial damage. And a criminal complaint for coercion based on the recording of the threat. She asked me which ones I wanted to activate. I told her all three. The process was complex because it involved authorities in 3 countries due to the international nature of the affected cases. In Mexico, where the firm was based, the Bar Association opened a disciplinary proceeding against attorney Herrera based on the complaint and documentation. Disciplinary proceedings at bar associations are not criminal processes, but have real consequences. They can result in suspension of practice, in a public reprimand recorded in the professional file, or in the loss of specific certifications. In the international arbitration tribunals, where the translations have been presented, 2 of them initiated internal reviews of their certification processes based on the notification my attorney sent them, with supporting documentation. The civil lawsuit for financial damage advanced in parallel. The criminal complaint for coercion was the fastest to generate movement. The recording was direct evidence, and the prosecutor's office admitted it without much discussion. Attorney Herrera attempted several defensive moves that I will describe briefly, because they are part of the story. He attempted to argue that the meeting recordings were illegal because he had not given his consent. My attorney responded with the applicable regulations that in that specific context allowed recording by one of the parties without requiring the other's consent, and that the case law on this in workplace threat cases was clear. He attempted to present internal firm documentation that, he argued, demonstrated that the certification processes followed the correct standards. The documentation was reviewed by an expert and found to have date inconsistencies suggesting that part of it had been generated after I filed the complaint. That attempt to construct after-the-fact evidence was the second most expensive mistake of his career after the recorded threat. In the end, the process resulted in an 18-month disciplinary suspension before the Bar Association, a negotiated financial compensation in the civil process representing a significant portion of the calculated financial damage, and the permanent notation in his professional file of the improper conduct regarding certification. It was not the total destruction of his career, but it was enough for the field to know what had happened. In the world of international arbitration, the circles are small and reputations are fragile, and 18 months of suspension with public cause is the kind of information that international clients consider before hiring an attorney. My career was not destroyed. It was paradoxically strengthened. Several colleagues in the field learned about the case and how I had handled it. The combination of meticulous documentation, legitimate recordings, and willingness to confront a prominent name in the sector with solid evidence generated a kind of reputation that attorney Herrera had not calculated when he made his threat. The reputation of someone who knows how to protect their work and is not intimidated. I have more clients today than before any of this happened, and I still record every briefing meeting, not because I distrust all my clients, but because I learned that records are not signs of distrust. They are signs of professionalism. And professionalism, when you truly need it, is the only thing that protects you from people who believe their power is greater than your evidence. It isn't. It never is. If you have the right evidence. If this story made your skin crawl, comment. Would you record your work meetings as a habit? Like if you believe documenting your work is the best defense. Subscribe for more real stories. Share with someone who works as a freelancer or contractor and needs to know their work has legal protection. Practical tip. If you work as a freelancer or contractor in creative or technical services, record your briefing meetings whenever the law permits in your jurisdiction. Keep all delivery emails. Preserve file metadata. And if someone threatens you professionally, the threat can also be evidence. Consult an attorney before making any move.